A lawyer drafting a will forgets to include the name of an important beneficiary, and there's no doubt that the testator wants to bequeath to that beneficiary. Can a court correct the lawyer's mistake? The court in Knupp v. District of Columbia came to a heartbreaking conclusion in just such a situation. An unnamed testator, a District of Columbia resident, executed a will about a month before he died. Paragraph 6 directed payment of any outstanding debts, expenses of his final illness, funeral expenses, taxes, and a few gifts to specific persons. The remainder of the estate was to go to the residual beneficiary listed in paragraph 8. But paragraph 8 didn't name a residual beneficiary. Nowhere in the will was a residual beneficiary named. Richard Knupp filed a construction proceeding and established that he'd been the residual beneficiary of the testator's prior 2 wills. The attorney who drafted all 3 wills testified that the testator had wanted a final will to make some specific bequests, but had directed that Knupp was to remain the residual beneficiary of the final will, receiving the bulk of the testator's estate. But the attorney had inadvertently failed to identify Knupp as the residual beneficiary in the final will. The attorney provided his notes of his conversations with the testator to prove the testator's intent. The trial court ruled that the extrinsic evidence concerning the name of the omitted residual beneficiary had to be excluded. The court couldn't reform the will to add a name omitted by mistake, so the residue is cheated to the District of Columbia. Knupp appealed to the District of Columbia Court of Appeals.